Thank you, Mr Speaker. Question to the Minister of Labour. When she said that the 90-day scheme is voluntary, quote, is voluntary, unquote, and, quote, is not compulsory, unquote, did she mean that an employer could not make a 90-day trial a compulsory condition of employment?
The Honourable Kate Wilkinson.
Mr Speaker, a 90-day trial can only be entered into if an employee agrees to it in writing. By definition, an agreement is not compulsory. If an employer wishes to take someone on using a trial period, then they must advise the prospective employee of that. Just like other aspects of an employment agreement such as salary and hours of work, this is open to negotiation. At the end of the day, Mr Speaker, the employer decides who they wish to hire and on what basis, and I would encourage all employers and employees to avail themselves of this fantastic and successful policy.
That's right.
Darien Fenton.
To the Minister. Is she saying that the only part of the 90-day trial period is, that is truly voluntary for employees is whether they accept the job or not?
The Honourable Kate Wilkinson.
No.
Darien Fenton.
Supplementary. Isn't it really only employers who this scheme is voluntary for, considering that they can choose whether or not to make it a condition of employment, and where the prospective employee has no choice in reality other than to decline the job?
The Honourable Kate Wilkinson.
No, Mr Speaker, I do not accept that member's assertion. Mr Speaker, it's really no different to a situation of an employer's advertisement requiring or insisting that a job is done on a Saturday. If an employee doesn't want to work on a Saturday, they should not have to apply for that job. If an employee does not want to take the opportunity and use the trial period to have a go, then they do not have to take that job.
David Garrett.
Mr Speaker. Supplementary to the Minister. How many people have come forward as part of the Council of Trade Unions' Roll of Shame campaign, and how many of these are members of the Labor Party?
Order. Order. Now, look, I just could not hear David Garrett's question at all, and this time it was Labor Party front benches making all the noise. It's not good enough. No, I must admit it was not the Honourable Annette King on this occasion. Order. It was not fair or reasonable or courteous to the House. David Garrett, please. Supplementary question.
Speaker, supplementary to the Minister.
Order.
How many people have come forward as part of the Council of Trade Unions' Roll of Shame campaign, and how many of these are members of the Labor Party?
Order. Really, I'm not sure what responsibility. I suppose in terms of, in fact, I don't know what ministerial responsibility the Minister has for that at all. I invite the member to rephrase his question and try and ask a question for which the Minister is responsible. Order.
Thank you.
Now, order. There'll be no more interjection from... I paid the Honourable Trevor Mallard a compliment earlier on in question time today. It may be that I was mistaken. Order. David Garrett.
Thank you, Mr Speaker. Has the Minister seen any reports regarding the contents of the Roll of Shame and the political affiliation of the persons on it?
The Honourable Kate Wilkinson.
Mr Speaker, I've had a look at some blog sites, but to the best of my knowledge, in the last 18 months, I'm advised that a total of 2 people have come forward as part of that campaign. That's in 18 months, Mr Speaker, and that at least one of those 2 members is a member of the Labor Party.
David Garrett. I beg your pardon, Darien Fenton.
Mr Speaker. To the Minister, if a prospective employee does not want to sign up to a 90-day trial period, but the employer has said it's a condition of employment, what options and rights does that prospective employee have?
The Honourable Kate Wilkinson.
Mr Speaker, they have the rights of anybody else. If they want the job, they can apply for it, or they can discuss it with the prospective employee and negotiate what terms suit both parties.
David Garrett.
Supplementary to the Minister. What reports has she seen about union support for grievance-free trial periods?
The Honourable Kate Wilkinson.
Mr Speaker, I've actually seen a report by the Australian Council of Trade Unions which supports a 3-month, 90-day that is, 3-month grievance-free period in their submission to the Senate on the recent Fair Work Bill. I look forward to New Zealand unions taking a similarly reasonable approach.
Darien Fenton. Order. Order.
To the Minister.
Order. I apologise to Darien Fenton on this occasion. I say to the National Party benches, I could not hear Darien Fenton at all. The level of interjection is unreasonable. Darien Fenton.
Thank you, Mr. Speaker. To the Minister. If she is now confirming that an employer is entitled to advertise a job with a 90-day trial as a condition of employment, and that the only way an employee can avoid the trial is not to accept the job, wasn't it somewhat misleading for her and the Prime Minister to have continually told Kiwis when they introduced this scheme that it would be totally voluntary for employees?
The Honourable Kate Wilkinson.
Mr. Speaker, the member is making some rather odd assumptions, but I can say that the scheme is voluntary for employees, and it's actually working very well. And employees are taking advantage of it, and they are getting the opportunity to get their foot in the door, and it's a win-win.
Point of order, the Honourable Darren Hughes.
Mr. Speaker, I seek leave to table a document from the Parliamentary Library outlining examples of workers who have been exploited under the scheme, and noting that the first worker is a woman by the name of Heather.
No, order. The member should not have done that last bit. He had identified the document. Leave is sought to table that document. Is there any objection? There is no objection. Question number 10, Paul Quinn.